Before I begin, I have an issue that I need to address. As you know, and I've made applications several times, the disclosure in the record is entirely deficient. We've been trying to deal with these redactions. There's still redactions for parliamentary privilege, which the government has not removed. There's no legal basis for, as you've already ruled, to redact any document on the basis of parliamentary privilege. There's also the issue, as I've re-raised by email as well, the issue with the notes of this witness. The process that was used in dealing with that needs to be reassessed. These are important witnesses. I need rulings, and so does everyone here. The rulings on the redactions are so important. And for example, Ms. Jody Thomas testified and said that she supported the invocation of the Emergencies Act. But there's a note that we got after we fought for the one redaction we got that said Jody Thomas did not. And it was put up on the screen. It was notes taken. It had one Section 39 redaction on it. So if that's a cabinet document, we can assume cabinet knew about it. And it states that Section 2, no violence, and they were trying to come up with a way how to make this work anyway. That would have been very helpful to have when she was on the stand under oath. This is happening constantly. There is thousands of documents that the DOJ's dumping.
If you can, I'm not looking for a speech. I understand there have been issues about redactions. I believe that one is one I ordered disclosed, and I believe you questioned somebody about it as recently as yesterday or the day before. I am not sure about the redactions, certainly for, just to qualify, the redactions with respect to parliamentary privilege. I didn't say it doesn't exist. I said it was novel and that the arguments presented were insufficient, and I ordered the 3 redactions disclosed. We received something, I think it's yesterday, or maybe it was even today, and I apologize, I haven't yet ruled on it. That's true. But I do my very best to make decisions. I try my very best to make them intelligent and thoughtful, and that sometimes is not done immediately. So that's sort of how I can respond to those points.
So, sir, I can make it very easy, and we've written your counsel for a set of them. So the law is such that where a redaction is sought on the basis of irrelevance, it is not the onus of the person seeking to have it redacted on the basis of irrelevance. It's the onus on the person seeking for it to be redacted. And the purpose for that is that all of the documents given to us are subject to the implied undertaking rule. So they don't become public until a ruling on their relevance is made.
Okay, well, I'm not in a position to rule on that. I suspect that's the request you made either yesterday or today. I don't know which, and I'm sorry, I'm not in a position to rule on it right now.
Sir, but...
So what I'd like you is if you could proceed with your examination, or that would be, I think, ideal at this stage, and I'll do my best to deal with the motion, the redaction issues as soon as possible.
Okay, but I just want to put on the record that throughout this entire proceeding, all counsel here, and we're on national television, this is supposed to be completely transparent. This is the purpose of this.
I'm doing my very best.
It's not your fault.
Well,
it's just the fault that nobody's ordering DOJ to actually produce what they're obliged to do.
Well, that's something you can deal with in another forum. I'm doing the best I can here. I think we've gotten a lot of disclosure. There are issues, and we're dealing with those issues that are raised as they are raised. We dealt with the ones you raised, I believe, at the end of last week, made some orders, confirmed some of the redactions, and we'll deal with your most current application.
But could you just not order that the redactions for parliamentary privilege, because I can tell you, I've studied that area in and out. And the reason no one could provide you an authority for the purpose of a redaction on the basis of parliamentary privilege is it doesn't exist. And parliamentary privilege is, of course, an ancient doctrine. And if you would just order the production of the records without those redactions, it would remove a whole bunch of them. Then, if you would order the production of all relevant records with respect where irrelevant is claimed, those records are then subject to the implied undertaking rule. And there's no national security issue with those. If they were, Section 38 would be claimed. There's no cabinet confidence so Section 39 is not claimed. And that has been the law. It's time immemorial. How can you contest if something's relevant if you don't know what it says? And my problem is that this witness is now on the stand. One of the documents is key in my submission. It is the notes of Ms. Jackson, which is the office assistant to this witness. There are redactions therein on the basis of irrelevance, and there are redactions therein also, I believe, on one of the other grounds. And I've sent a written motion, if you will, email to your council. We've been asking for these things and asking for proper production throughout this proceeding. All council are in agreement that we don't have proper production, sir.
Okay, well, I'm not sure you can speak for all council, and I'm sure they can speak for themselves as to whether or not you've been asking for this a long time. I'm not aware that you asked about those redactions,
So,
but maybe I don't have the records. But
so sir,
anyways, we're going to have to stop this.
Yeah.
And despite your belief that the law is always very clear, my experience of 20 years is that's why judges are around. So if you could proceed,
Yes.
otherwise, we're not going to get anywhere. So
So if anything in your conversation on February 4th in that note would be relevant,
I don't know.
and I take it when you spoke to Ms. Telford, or sorry,